One of the many reasons I enjoy doing this channel and these videos is I really like all your comments. So thank you for doing those. They give me ideas for future videos, but they're just really interesting to hear your take on the subjects I talk about. And I know a lot of you have very interesting and sometimes strong opinions on the criminal justice system, but you now have an opportunity to have your say and perhaps influence the criminal justice system. Although you're going to have to be quick about it because you've only got until the end of the month. But what am I talking about? Well, there is now an independent review of the criminal courts, and that's being conducted by Brian Leveson. It's interesting, just a little side note. I remember actually sitting with Brian and a few other people just before he went up, because he prosecuted Rose West. And it was really interesting to hear how he'd planned it, because of course they'd all planned to go against, the case had all been prepped to go against Fred West, and then he sort of removed himself from the picture. And it was just her in the dock. And we talk about this theory of the case. I've mentioned this before, where the idea is that you encapsulate, your sort of basic argument in one very, very simple principle. Ideally with a sort of catchy catchphrase that you can use to the jury. The classic example from America is, if the glove don't fit, you must acquit. And Brian said that the one they were going for was, she must have known. So that was the entire theory of their case. So a little Leveson side note there, just to give you some context. He's a really nice guy. He also did all the stuff into the newspapers, the phone hacking. He did the inquiries there. I remember also, again, just to do little anecdotes, I know you like these, I was actually doing a defamation case while they were doing the Leveson inquiry. And as you know, I used to work for certain newspapers, and it was really weird sort of walking past the people waiting to give evidence. Some of my old colleagues are like pretending not to recognise each other. It's like, oh, tum, I'm just here for something totally unrelated to this. But anyway, yeah, what's the actual problem? Well, the problem is, as they set it out in the sort of application for comment, the Crown Court caseload has risen substantially over recent years for complex reasons, basically, not winning money, including the pandemic and an increase in the number of cases coming before the courts. The scale of cases entering the courts is now so great that even with the Crown Court sitting at historically high level, this would not be enough to make meaningful progress on reducing the outstanding caseload and bring down waiting times. Doing so will require bold thinking. Not sure about bold thinking. Remember in Yes Minister, where if Sir Humphrey ever wanted to put Jim Hacker off something, he'd just sort of say, that's a very bold suggestion. It's like, what do you mean bold? It's like, it's an interesting suggestion loses your votes, a bold suggestion loses you the election. But they're clearly sort of, thinking about some big root and branch reforms. We've had inquiries before. There was a review in 2001 by Lord Justice Auld. And indeed, Brian Leveson had a sort of mini review in 2015. That was his report, Efficiency in Criminal Proceedings. And that suggested some minor tweaks. And most of those have actually been implemented. Although one of the things they're on about in this review is looking back to see if there's anything else that they need to do based on those. But the Lord Chancellor, she has now said, OK, let's see what people think about all these. Now, this has all just been put out to sort of professional court users, like lawyers and judges. But there's no reason that you can't have a say. You are the public. You are the ultimate consumers of the justice system. So, and like I say, I know from your comments that a lot of you have very interesting thoughts about this. So what are some of the things they're looking at? Okay, it says, well, the review should consider longer-term options for criminal court reform with the aim of reducing demand on the Crown Court by retaining more cases in the lower courts, that means the magistrates' courts. This could include the reclassification of offences from triable either way to summary only. So what does that mean? Well, summary offences are offences that can be tried in the magistrates' court. Indictable offences are offences that can be tried in the Crown Court, but we also have either way offences, which can be tried in either. And in order to be tried in the magistrates' court, both the magistrates and the defendant have to agree. So first of all, the magistrates have to say, this is a case we think we could legitimately handle. It's within our powers and it's within our sentencing powers, and in terms of complexity and stuff, it's perfectly, it's fine for a magistrates' court trial. But even if they do that, then it's up to the defendant. The defendant can say, well, I don't care what you say, I elect a Crown Court trial. I want to, do this in front of a jury. The magistrates can say, well, actually, we think this is too complicated for us, or if you are convicted, our sentencing powers wouldn't be enough, so we're going to boot it off to the Crown Court, regardless of what you say. There is, though, even if you are actually tried in the magistrates' court and ultimately convicted, the magistrates can actually send you to the Crown Court for sentencing anyway. They go, well, now we've convicted you, we actually think our sentencing powers aren't enough because we can only give you like 6 months for one offence or 51 weeks for more than one offence. And we think you need more than this. We're going to send you to the Crown Court to be tried. So, is there any really advantage in being tried in the magistrates' court? Some people like it because it's quicker and generally the costs are less. But I think most people who, want to fight a case tend to elect jury trial. They're also looking at consideration of magistrates' sentencing powers. Because they keep coming back with this thing that, if we just give the magistrates more power, then there'll be more magistrates' court trials. Because people say, I'm happy to be weighed off in the magistrates' court, and now you can sentence me to 5 or 10 years. Well, that's great. So let's all crack on with it. I'm not convinced about that. A very novel idea is the introduction of an intermediate court, something between the magistrates' court and the Crown Court. At the risk of giving my own views here, I'm not sure that we actually really need that. I think the current division is fine. And we do have similar things in civil trials. In civil cases, we have these different tracks. We have the small claims track for cases under 10,000. We have the fast track for cases that we can probably deal with in one day or less. And then we have what we call the multi-track, which is for the big sort of complex stuff, cases that are going to last more than one day. Even in there's talk of introducing an intermediate track that would fit somewhere between the fast track and the multi-track. Although, like I said, generally speaking, we have the county court stroke high court split there. And generally speaking, the lower value stuff, even if it's a fast track, tends to stay in the county court. A lot of the multi-track cases end up in the high court, but there is some, a county court can do a multi-track claim. And the High Court actually can do hearings, especially when it comes to things like summary judgment that take less than a day. So there is quite a bit of overlap there. They're also looking at any other structural changes to the courts or changes to mode of trial, that's whether it's Crown or magistrates, that will ensure the most proportionate use of resource. And I think that's the giveaway, really. This is all about finance. Because you could fix the system tomorrow just by throwing more money at it. There is this amazingly massive backlog of hundreds of thousands of cases, and it's only getting worse. But the problem is, like I've mentioned before, governments, not just, previous governments, other government, this government, none of them have particularly funded the criminal justice system very well. They've sold off loads of court buildings. So there's just not the room to, have the cases. There's a shortage of judiciary. There's a shortage of lawyers. Both prosecution and defence, just because, publicly funded work just isn't sustainable. It's really badly paid, and you wait ages for the money. So, that's one of the reasons. And even when the courts are operating, they're usually only operating at sort of 70 to 80% capacity at best. So you'll go down to a court and courtrooms that were available, physically there, people just aren't using them. My local court, they looked at, they were going to go on to a 4-day week and said we'll only sit 4 days a week. There was a bit of a backlash by the local bar, and they've changed their mind on that, so they are now sitting. Because if I was going, well, hang on, that just basically pumps the workload back onto us because we've still got all the work to do. We've just got less time to do it, so there'll just be yet further backlogs. But saying in relation to these reform options, the review should consider the impact any changes could have on how demand flows through the criminal courts, the potential impacts of any structural changes on the fairness of proceedings, particularly the impact on court users such as witnesses and defendants, and how these could be mitigated where necessary. The necessary enabling processes to ensure that the most effective implementation of the options, for example, the allocation process. I mean, what they're saying there is it might be they need to pass, do we need new legislation to deal with this, or can we all deal with it just by tweaking the rules that you've already got a discretion to actually change? Because you have there's the criminal procedure rules, and they're set by a rules committee of senior judges, and they just sort of sit around. And there's always this big thing about, can the rules override statute? No, because statutes, legislation, acts of parliament, by definition, are the sort of highest authority. So it's whether they have the power to tweak things by using their inherent rules powers, or whether they need legislation. The implication for appeal routes of the various options. I mean, like say, for instance, now, if you are convicted in the magistrates' court, or you plead guilty and are sentenced in the magistrates' court, you actually have an automatic right of appeal from the conviction and the sentence. You don't need a leave to appeal. And it's not an appeal in the traditional sense, where the court can only interfere if the lower court got it very, very wrong, sort of like made a decision that no reasonable court could have done. It's actually what we call de novo hearing. It's basically you get another go. You just start from scratch, and you do that in front of a judge and two magistrates. So, but for everything else, if you want to appeal from, say, a Crown Court conviction, you have to get leave to appeal, either from the initial judge, and sometimes they will grant it. They will say, well, I directed the jury on the law in this way, and I know you said you thought I got that wrong, and maybe there is something, in your argument, so I'll give leave to appeal. More often, though, you have to get leave to appeal from the appeal court, because you'll get knocked by because most judges say, well, I think I got that right by definition, so I'm not giving you leave to appeal, or permission to appeal, it's sometimes called. But the Court of Appeal themselves can say, okay, yeah, we're not saying the judge did get it wrong, but we're saying you've got an argument that they got it wrong, so we'll give you leave to appeal. And then you can do the full appeal. I mean, sometimes we have what we call rolled up hearings, where they'll consider the leave to appeal, and then if that's successful, the appeal follows straight away. I mean, that's usually a good sign. If you see it listed for 15 minutes, your leave to appeal application, you've got a good idea they're going to knock you back. If you see it listed for like 3 hours, leave to appeal with appeal to be heard thereafter if granted, and they've set aside 3 hours, maybe you've got a punt on that. Necessary changes to thresholds and mode of trial within relevant offence types. That's things like criminal damage, where depending on the value of the damage, that decides whether it's a summary-only offence or a triable either-way offence. So I don't know about like shifting that. So it might be criminal damage under £10,000 can only be heard in the magistrates' court, something like that. But higher than that, then you've got the right to elect a jury trial. And the sequencing of any changes, for example, whether they should be brought in via a phased approach. In other words, do they just say, right, here's what we're going to do, and see you next week, guys, because that's when we bring the new rules in? Or do they sort of bring them in on a sort of rolling basis and let people, sort of have time to adjust? Then they look at the efficiency and timeliness of processes through charge to conviction or acquittal. This should include consideration of how processes through charge to conviction acquittal could be improved to maximise efficiency. This includes looking at the processes of the courts, but also those of partner agencies in the criminal justice system, which affect the efficiency of the criminal courts. So that could be things like, okay, let's say we want to deal with people very quickly. They are convicted and we want to sentence them, but we need a pre-sentence report. You've got to look at how can the probation service handle that? Do they have the resources? Do they have the time? Do they have the staff? I mean, back in my day, and this might have all changed now, we would sometimes get what we call stand-down reports, where you say, before you sentence this person, we need a pre-sentence report. It doesn't necessarily have to be a massive full one, but can we just come back this afternoon? In the interim, they'll pop off to probation in the court, and the probation service will just do a very sort of quick overview. And they'll either produce a little pro forma pre-sentence report. Sometimes they actually come in and they would actually effectively give evidence. They'd say, yeah, I've spoke to this person, we think they could handle community service, or prison would be very bad for them because they've got this wrong with them or this wrong with them, or we recommend there's a particular course that would really suit them because, we used to do the Think First course a lot. Because in all fairness, I mean, my experience of criminal justice, you do get quite sympathetic because, oh, don't get me wrong, there are some people out there who are just bad. They're just bad people. But a lot of people end up in the criminal justice system through, desperation and circumstances. And a lot of the time, it's just people just didn't think. They just do daft, stupid stuff. So the idea is you have this think first course. And I've said before, especially like young offenders, the best way to stop a young offender becoming an adult offender is not to catch them. Because people grow out of crime and, they get a steady girlfriend or they get a job or they just get more mature and they just stop offending, Whereas, if they get caught and they're in the criminal justice system, then, they get dealt with, they have criminal records, it makes it harder to get a job, they're more likely to be suspects in future offences, all that sort of thing. Also, consideration of how effectively previous recommendations including those contained in the 2015 review, have been implemented, and if more could be done for these to successfully increase efficiency with the criminal courts. So that's what I'm saying, looking back, because it's like a bit like the J inquiry. It's like, you can have all these inquiries and they can make brilliant recommendations, but if you're not going to implement them, what's the point of them? So that's something to consider. Consideration of the previous recommendations within the current context of challenges facing the criminal courts and how these may be updated or built upon. I mean, one of the things previously is that the government said, yeah, we will find additional funding. So you can take that into account when looking at, how we're going to change things. But now they've said, no, there is no additional funding. Forget that money's not there now. So forget all this reducing the backlog stuff. We can't do that merely by, paying people to do the job. Or, actually having the buildings. They're just saying the criminal justice system as it currently is just cannot function anymore. The backlogs are going to increase and increase and increase until it eventually just collapses. And the one I found is, this will be interesting to hear your opinions. Consideration of how new technologies, including artificial intelligence, could be used to improve the criminal cause. Well, I'll say now, personally, I'm very sceptical of artificial intelligence at the moment. I mean, people have tried using it in the law, and most of the time it's come back where we know about these because people have put in submissions and arguments generated by AI, and they're just wrong. They refer to cases that don't exist, or they get the ratio, they get what we call the ratio, what's the decision in the case? Why did the judge, what principle did the judge set out? They just get it wrong. There's an interesting one in the US where some people put in a brief that was all AI, and it just made things up, it hallucinated. And the lawyers actually got sanctioned. The court said, right, this is definitely a disciplinary, because, the whole point of lawyers is you're meant to know what to do and do the work yourself. But interestingly, when they sanctioned them, they said, the sanction is that every lawyer on Twitter has just been taking the mickey out of you for the past 6 months, and you are now laughing stocks in the legal world. So we will consider that to be the punishment. But there has been talk about using AI, first of all, just to filter cases. I mean, maybe just filtering things, as long as then there's a human input. But there has been talk about using AI to sort of make decisions, which I find very worrying. I mean, to come back from the civil context, which I normally do, getting very opinionated now. But the master of the, I think it was master of rolls, don't get the wrong person. But we'll say a senior judge, so you don't get sued. A senior judge said, well, when it comes to sort of most like low-end stuff, people aren't really bothered about whether it's the right or wrong decision. They just want a quick decision and a cheap decision. Well, I am not convinced about that because, meeting real clients, okay, if we're just doing some small claims track for a few £1,000s, okay, it's not a big multi-million pound, £100 million case, but to those people involved, it's still very, very important. What if it's like a boundary dispute? Okay, you're arguing about, a strip of land worth £1, but it's still something, that people get very strongly about. Or people just chasing debts. It's like, I'm not being paid, and I'd like to be, I did the work. Or people going, well, this was negligent work, I shouldn't have to pay it. It is important to them. So I'm very sceptical about sort of automating the process. Because, when it comes to this theory of the case thing, I always tell all the young barristers and the pupils, when you're making an argument, Okay, it has to comport with the law, it has to comport with the facts, but fundamentally it has to be an argument that's easy to believe, it's easy to swallow, it comports with common sense and human experience. I mean, I would say, if you've got to say to a jury, well, look, this is what we say happened, now using your experience, does that sound quite likely? We've all been in situations where we've had that, where we've had this pressure, or, this is how humans react. Whereas if you've got to sort of say to a jury, I need you to exercise some mental gymnastics, because I appreciate this sounds very implausible and unlikely, but as a matter of law, this is what you would have to find. You're always on an uphill battle there. So I think removing humans from the equation, and this is why I'm a big fan of juries, because then you get, the collective experience and worldliness of 12 people of reasonably different backgrounds, and they all bring something to it. It's like a gestalt entity, and the whole is more than the sum of its parts. I've always been, I'm a big respecter of juries. I think, generally speaking, juries are very, very smart and take their responsibility very seriously. And let's just say, I've never had a jury decision that I've been shocked by. I've had some acquittals that have surprised me. I remember once when we had a sort of like, and now, do you find the defendant guilty or not guilty? Not guilty. Right, thank you. Stand up. Now, sorry, did you say not guilty? I mean, even my guy had stood up. It's like a bit of a giveaway there. The most embarrassing one was when we had they came back with a not guilty verdict, and I saw the judge whisper to the jury usher, the jury bailiff goes, "Is that our jury?" That was great, that, isn't it? It's like, it was our jury. Obviously, my fantastic closing submissions had obviously done the trick. But I've never had a jury I've had juries where I thought we were in with a punt, but they'd convicted. And I've gone, okay, I felt we had a bit of a punt there, but it's not unreasonable, based on the evidence, for them to have convicted. But I've never had a jury where I've just gone, that's just like completely a perverse conviction. But anyway, so also, in addition to the above, the review should make any recommendations to tackle the outstanding caseload that emerge as a result of reviewing the options and evidence. The review should consider what can be learned from best practice in other jurisdictions and international comparators. But also, the review should not consider wider cross-system efficiencies where they do not relate to the efficiency of the court. So if you're going to submit stuff, don't sort of say, oh, it's all rubbish and they don't collect the bins on Tuesdays anymore, or anything like that. It's just a symptom of, finance of the government as a whole. Stick it to the criminal justice system. Because they say, although as outlined above, the review will consider processes of partner agencies which affect the efficiency of the criminal court. So that'll be like probation and indeed just the police. Can the police, can they nick people? Can they get them to court on time? A big problem, again, with backlogs is jails just not getting prisoners to court. And there was a bit of a thing this where they were sort of going, oh, well, he's not here, he was uncooperative and he refused to get on the van. And some judges got suspicious of this and said, okay, let's see the logs, because you'll have to fill out a form. And then it'd been like G4S becoming like, sorry, when we said won't get in the van, what we actually meant was we didn't have a van that day. Which is really bad, because they blame it on the poor old prisoner, who's now looking like he's uncooperative. Oh, he refused to come to court. It was all, kicking off. And it's just like, no, you just hadn't booked or allocated a van that day, or your driver hadn't turned up. So that is something that needs to be done. I mean, in all fairness, like now judges are getting very wise to this, and they're saying, right, I want the prison governor here to explain what happened then. If you're saying, this happened, this is a very serious offence. This is very serious. Get here and tell me all about it. And, calling their bluffs a little bit. They say it's important that this review complement the other work that is currently ongoing, which aims to improve the criminal courts. For example, the work of the Criminal Courts Improvement Group will continue, focusing on short-term operational improvements that can continue to be made whilst independent review is underway. So that's basically, this courtroom's seems about to collapse, but we can stick a porta cabin in the car park. That's that sort of thing. And as part of the review, relevant partners across the criminal justice system will be consulted and engaged to ensure any subsequent recommendations are both operationally viable and consider other ongoing or planned works to improve efficiency. And they say, finally, the options and recommendations provided should take into account the likely operational and financial context at the time they may be considered and implemented. In other words, look, at the end of the day, this is all going to come down to money. So the report, they'll get back supposedly in spring 2025 and then produce a follow-up in autumn of 2025. So you've not got a lot of chance to get your submissions in. They have to be in by the 31st of January, i.e. the end of this month, which is what? That's like, so you've got 2 weeks basically to do it. So thanks, court. I mean, I think they only announced this very recently. But I'll put the email in the description so that if you do have any thoughts on this, you know, be heard. You know, you are the public. You are the consumers of the criminal justice system, whether as victims, witnesses, or defendants. So, you know, you need to have a say in this. So yeah, so I will put that email link in the description. And like I say, I've explained what the sort of things they are considering. So don't go, you know, you don't need to go into any massive polemics about the government generally or just the state of the country, but specifically the questions that have been addressed. Because some of them are very fundamental. I mean, some of it is effectively, it's all in very anodyne language, but it's effectively saying we're going to abolish the right to jury trial for some offences. You know, and should that be the system? I mean, you don't need to look at the offences themselves specifically, but you can look at, I mean, people have said about how come some cases get dealt with very quickly and some take months to come to trial. And I've done a few videos on how that is usually, you know, if people plead guilty at an early opportunity, then they can be weighed off very quickly. And if they've been held in custody, then they get on quicker than if, you know, they've been bailed and things like that. But, you know, that's the sort of issues that you might want to consider. So there you go. So have your say, members of the public and my lovely audience. You guys got any comments on that? Cappy Barrister and Lord Lubaduck? No, they're just looking at me like, just stop rambling and get on with it. So I'll do my usual sitting over here. Apparently people like my supposed kung fu poses. I wasn't not sure if it really was kung fu. I mean, like I said, I like traditional martial arts, but I don't really practice them, so I don't know. So I apologise if I'm getting the forms wrong, because I'm sort of like, you know, reality-based self-defence. So it's all sort of that sort of stuff, and palm strikes and hand strikes and all that Fairbairn Sykes World War II stuff. But there you go. Maybe if I just do that, sort of like, leave a little bit of room for the title, Criminal Justice. Well, now you two are in the way. Hang on, just come here, say hello to everybody. Hello! And just go like there. And I've left a bit of room for the title. Have your say. That's quite good, isn't it? But that'll work. Yeah, have your say. And as always, hope you found that vaguely interesting, vaguely informative, and vaguely accurate.